Sheriff's office.
Oh, hey.
You think anything about this is okay right now?
Imagine as a parent that you call 911 asking for an ambulance because your son needs help.
I'm trying to call an ambulance. Do I have to call the hospital?
No, sir. We dispatch an ambulance. What do you got?
It's my son.
But instead of an ambulance, cops arrive instead without an ambulance. Why? Because the cops have a warrant for the son.
It's this one, right? That one? I don't know. Sheriff's office.
And as soon as the cops get there, instead of medical treatment, the son gets immediately tased.
Oh, hey.
I didn't even know this at the time, but apparently just days after I posted the video 2 years ago, they completely got rid of this guy. Whether he resigned or he was fired, I don't know. Scratch that one down as yet another example of YouTube taking down one of the bad apples. Did he pop up somewhere else? I'll tell you what I know. A civil lawsuit was filed, and just recently it was settled. Let me know in a comment what you think. How much do you think this case actually settled for at the end of the day? This happened back on June 18th of 2021. This was in Union County, Illinois, involving the Union County Sheriff's Department. On June 18th of that year, Jacob's father called 911 seeking an ambulance for his son. He was suffering a mental illness emergency due to the unfortunate meth addiction that he had at the time. And at that time, he was a very small, perhaps slight 27-year-old man who had suffered from long-term drug use and mental illness. He was at his home in Jonesboro, Illinois. This is only 1 block away from the Union County Sheriff's Department building and 1 block away from where ambulances are dispatched to citizens in need. Even though Jacob's father called for an ambulance never arrived. Here's the actual 911 call, where Jacob's father was told that an ambulance would be dispatched.
911, what's the address of your emergency?
I'm trying to call an ambulance. Do I have to call the hospital?
No, sir. We dispatch an ambulance. What do you got?
It's my son. He's psychotic right now. He's in a psychotic state.
Okay.
He had a relapse about a couple weeks ago, and he's going nuts.
But instead, several law enforcement officers arrived, including Sheriff Harville, Chief Wilkins, and Deputy Schildknecht. Still, 2 years later, no idea if I pronounced that correctly. All 3 of those cops knew that Jacob was reported to be having a mental health breakdown. Basically, the call was that he needed emergency medical assistance. The deputy admits in his report that Jacob was having a mental health crisis. That's why he was there. He noted that he received a report that Jacob was having a mental health crisis, described as psychotic, and that an ambulance was needed. He then wrote, "I also knew that Jacob had a felony warrant, as well as a history of running away naked from help when we arrived." All the cops present knew, or should have known, that the felony warrant that existed was not for a dangerous or serious criminal offense. In fact, they were the police department that requested the issuance of the warrant. And for similar reasons, these cops also knew that Jacob was not even aware of the fact that a warrant had been issued. So Jacob had no idea the cops would be coming to arrest him for any warrant. Upon arriving on the property, the deputy contacted the individuals who were at the residence, and they indicated that Jacob was in the backyard of the home.
It's this one, right? Right here? Shut up, Todd. That one?
I don't know. Oh.
Hello.
Is this the one that comes from this one?
Yeah.
Sheriff's office.
When Deputy Schildknecht approached Jacob, he just instantaneously fired his taser at Jacob.
Yep.
Oh, hey. Please stop.
He wrote in his report that he allowed the taser to run for the 5-second cycle until Sheriff Harville could get there to assist. Jacob's friends and neighbors looked on as he writhed on the ground in pain after being tased while he's screaming out in just excruciating pain. Deputy Schildknecht's report admits that he tased Jacob in the back as Jacob turned to run away. The deputy mentions no immediate safety threat as being the basis for this use of force. As I walked through the residence and came to the side door, Jacob saw me, turned and began to run away from me. At this point, I raised and fired my taser at him as he ran away. I was unable to issue a warning to him because the situation evolved so quickly. None of the law enforcement officers had announced their presence, nor the reason for their presence. They had not identified themselves or mentioned why they were there or that they had a warrant. After they tased him, the cops discuss whether or not they're going to allow Jacob to ride in the ambulance or whether they're going to take him in the police car, which is ultimately what happened.
Oh, that's not my fault.
We'll take it. No, if it's Jacob's, it's going into evidence. Did you grab that taser, Scott?
I didn't get it.
Yeah, it's a taser. We're grabbing it. It's not okay. You think anything about this is okay right now? All right. All right.
Are we going to sheriff's office?
We can't.
Because they're going to have to.
I know. Let's get the ambulance service up to the office.
We ought to just take him to the hospital, Scott. We don't want to fight him in the back of an ambulance.
Yeah.
That's true. Let's take him.
I'm trying to be a dick, but
I know.
I say we just.
I agree. But we're going to have to get some more units out there because he don't fight like
County K-9 1. When the deputy asked, "Do you think anything about this is okay right now?" that actually aged pretty well, because nothing about it was okay. But before I posted this footage on the internet, nothing had been done about it. According to the lawyer who handled the civil lawsuit, he wrote, "The deputy resigned shortly after the incident was exposed on the popular website The Civil Rights Lawyer. The post generated hundreds of online comments, many expressing outrage over the deputy's tase first, ask questions later approach. Nevertheless, the defendants denied any connection between the deputy's resignation and the website post. According to the deputy, he was not disciplined for the incident. So he resigned after I posted the video. In fact, looking at government payroll records, I can't see where this particular deputy has been given any sort of a government salary while working as a police officer. And I found no record of him working anywhere else. So I'll scratch that one down as yet another example of YouTube taking down one of the bad apples, when none of the supervisors or elected sheriffs or county commissioners or anyone else would actually do anything prior to the public becoming outraged. Rather, the environment around there was apparently so bad that the deputy who did this complained about and apparently received compensation for his broken Oakley sunglasses that unfortunately were broken when he violently attacked this man in violation of the Fourth Amendment. You may ask, what about this incident violates the Fourth Amendment when I see taser videos all over the place that don't look a whole lot different? Illinois is in the 7th Federal Circuit, so we look there to the case law, which is similar to other circuits. It says tasers are considered a significant level of force. Officers may not use significant force, such as the deployment of a taser, on non-resisting or passively resisting suspects. The 7th Circuit has also made clear that police officers can't just use tasers as a tool of convenience to just seize somebody rather than physically attempting to seize them first where there's no danger or immediate safety threat to the officers. In Lewis versus Downey, the 7th Circuit said that the tasing of a jail inmate with no warning who was not threatening the officer is excessive force. Here, the deputy even wrote in his report that he didn't give a warning prior to tasing this individual, who had no way of knowing he was under arrest, who was not told he was under arrest, just saw him and tased him. And that was actually in violation of their apparent department policies. According to the Union County Sheriff's Department Policy Handbook, which presumably this deputy was given a copy of and at least reviewed in his years on the force there, said that explicit verbal announcement
of the intended use of a taser shall precede the application of the taser. So you have to give a warning first. This officer violated his own department policy. The policy further provided that the fact that a person is fleeing should not be the sole justification for the use of a taser. And that was the only justification given by the deputy in this case. Also, the Union County Sheriff's Department Policy Handbook further provided that even if otherwise authorized, the use of a taser should not be used against individuals who are known to be or obviously are medically fragile. Indeed, the Seventh Circuit has cited I believe the Ninth Circuit in stating that people who are known to have mental illness should not be treated like they are violent criminals, and significant force such as tasers should not be used when there are multiple officers around and no immediate safety reason to use a taser. So this is, as they would call it, a bad tase. It violated their own department policy. There's not much of an argument there, in my opinion, that this violated the Fourth Amendment. All right, let's get to the settlement. As citizens, our only recourse for the government violating our constitutional rights that we can prosecute ourselves is to file a Section 1983 lawsuit in federal court. The only thing we can get there is money. We can't just directly get anybody fired or disciplined or anything like that. Hopefully those things happen as a byproduct, but all we can do, the remedy that Congress gave us, is a monetary award in an amount ultimately determined by a jury. This case settled before getting to jury trial, with both parties anticipating what a jury might do. That means these cases are always fact dependent, including on the estimation of whether or not a jury is going to be sympathetic with somebody with a long history of meth addiction, because a lot of jurors out there are just going to say, well, F around, find out. This was litigated in the Southern District of Illinois. No idea what the jury pool is like there, but the amount that both parties agreed on was $58,000. So let me know in a comment what you think. Is that too much? Is that not enough? These cases are very difficult. We have to take the wins where we can get them. Here, the officer is no longer policing that community. He's not going to do this again in that community. Hopefully an example was made out of him. And the only reason that occurred, that there was any accountability, any justice whatsoever, was because of a YouTube video. The public was outraged, and then there were consequences. But that's only possible so long as you participate. So it's very important that you subscribe. And even though sometimes these videos are hard to watch, if you don't watch them and you don't share them, then perhaps there's no accountability at all. The government's only going to care if they know that someone is watching. So continue watching. So please subscribe both here and at the blog at thecivilrightslawyer.com. You can also follow me on Twitter at JohnBryanESQ. And yes, I'm a little bit sunburned. I just got back from a week in Florida where I got to go fishing for redfish. Big shout out to my guide down there, Captain Tracy Collins. If you want to do some of the most fun fishing ever, Cedar Key, Florida, Tracy Collins, super great guy, super affordable. Highly recommend. I can't wait to do it again. Remember, our rights don't end where your fear begins. Freedom is scary. Deal with it.